far. And we will have recordings posted in our channel. We will inform you about it too. I think we can start now, unless Jacob doesn't want to add something before we start.
I have my comments prepared, and I'm very much looking forward to the presentation. So,
please. All right. Okay. So, Nicola, would you start, please? Please unmute yourself, and you can start. Thank you for being here. Hope you enjoy the session.
Thank you everyone. Karina's gonna introduce our research first. So Karina, please go ahead.
Can you see my presentation? Yes. Okay, so good morning, everyone. We're very grateful and honored to be here today. We would also like to thank our commentator, Professor Jacob, all the participants, attendees, and congratulate the event organization for such an amazing initiative. Today we are here to present very briefly our preliminary results of our research focused on judicial diversity in a cross-country perspective. So our paper is structured into 3 main sections. First, we describe existing studies on judicial diversity and their limitations. Then we detail our data set and discuss methodological challenges of such an endeavor. And third, we delve some into preliminary conclusions regarding how diversity has evolved over time and across different aspects. So today, we're focused only on sharing with you our methodological and research design choices and the challenges we faced in the research. And Nicola will present part of the results we have achieved so far. So by now, we know there's still a lot of work to be done on the correlations and construction of hypotheses by country and by region, but we are very optimistic because we have a lot of possibilities based on our database. So how we design our database? We sought to advance and dialogue with the existing literature. So we aim to investigate not only who is in power, but also how they reached those positions, meaning what could be the factors that drive to their access, internal recognition, permanence, or even the departure from the bench. So as we observed, diversity researches are mostly focused on gender. So we managed to assemble other different layers of diversity besides the gender, such as race or ethnicity, age of justice, social, cultural, and economic origins, as well as their participation in the sort of professional or social circuits that could make the rise to these posts. So we were first inspired by US database such as Leipzig database that houses approximately 245 variables, but also we compared the US database with other comparative experience so we could have a better understanding about how far we could go in a cross-country analysis based on diversity. So in our case selection, we choose to compose a representative and descriptive overview of the composition of constitutional courts in modern democracy. So we include all higher courts that carry out judicial review without considering the extent of the attribution, whether it's a Supreme Court or a constitutional court. And to measure democracy, we use Freedom House Index. So in case that these courts underwent reforms or the body was replaced, we include the information of both bodies. We also included information, for example, about the Caribbean Court of Justice, since many countries in the Caribbean didn't have very much information available. So we were trying to fill these gaps. We created 2 main databases. The first one related to the court's normative design. So we compiled constitutional rules, infra-constitutional rules in each country. We got it from the Constitute Project and other resources. And the variables define the number of members, term of office, who are recruiting authorities, the quorum selection, and procedures, and the requirements for the position. The other database, we have more than 1,500 observations. We observed the justice information. So we have more than 40 variables. We divided into 7 categories. So we have personal identification data from the justice, name, country of origin, year of birth, gender, photos, and etc. And regarding their mandate, we collected also the term start, end date, reasons for departure, the stakeholders who had veto powers in their personal nomination and appointment. So we have a lot of data about their mandates. And also we collected data on educational background, bachelor, master, and doctoral degrees, and their professional background. So if they were justice before, or judges, or they were politicians, this kind of information. So we mainly prioritize official data source, but sometimes we needed unofficial source too, such as, for example, news and biographical interviews, so we could deepen the information we had. The main challenges we faced in our project, just to share with you, were related to access reliable data and also with the classification of race. So several courts only have information about current justice, and when they have the historical, they don't have deep curriculum information. We contacted the courts, but mainly we found that the courts that have online available information responded us, but the ones that didn't have available information, they didn't. So, and the second major methodological challenge we had was to define objective criteria for the analysis of racial diversity. So many courts do not provide, or they don't even collect race and ethnic data of its components. Even demographic data is hard to find. So as we couldn't collect just self-identification, we observed good practice for hetero identification, other person, third parties identifications of race based on photos. We have recommendations from the OECD report on diversity statistic. We also had, in Brazil, we have some good practice doing that because we have quotas, racial quotas, so we have a lot of information and legislation on it. So our research design led to a final selection of 51 countries over a period of 20 years. So we found data we found the composition of these courts from 2001 to 2021. So we identified that this period could cover a good part of constitutional reforms and also the policy initiatives on diversity. So Nicola now will explain a little bit more about the results so far we achieved. Thank you.
Yeah, thank you, Kari. So we have some few preliminary findings for you guys. We have some more that we can share in the Q&A if necessary. But here we've prepared just a couple of graphs and a couple of tendencies that we think are interesting. So the first regards gender diversity, right? So that's the question that most of the literature has discussed, although cross-national data in relation to this is still lacking quite a lot, and our database kind of fills that gap. So we try to first answer, well, how has the female participation and representation in high courts changed through the last 20 years? And we can clearly see a significant increase in female participation in courts, which kind of follows a general trend, not only in courts, but also in all other professional activities of life. And apart from that, we actually got the data from the World Bank, which accompanies the evolution of can I go back 1 second? The evolution of gender in parliament. So you can see that gender participation of women in parliament has increased, but it has increased at a slower pace, and courts are significantly more represented by women than parliaments, which is an interesting finding if we consider that the representation of women is an important part of legitimacy of these institutions. So we also tried to see if there was some kind of variation between different regions, and we find that there is variation. North America being the region with most female participation, and South America, which is where we are from, which is still a bit lacking in this regard. But we see a tendency in Europe. There has been like a gradual increase in the last 20 years of female participation, while in South America this seems to have happened during the last 10 years. So it seems that the movement towards gender diversity seems to have happened before in Europe and reached South America perhaps a bit later, and that reflected in courts in a later time. So there are a couple of theories that we wanted to test from the beginning. The first of them is the substitution hypothesis. So one might perhaps consider that gender diversity will increase for one reason, because it's harder to substitute a women for men, right? The political cost of, after a woman retires or leaves the court, to replacing her with a man might incur in some political costs, which would lead the appointing institutions to appoint another woman. We saw some of that dynamic in the United States, and so we tried to test that in a more comparative perspective. But we found no evidence in support for the claim that this hypothesis actually bears fruit, at least in the last 20 years. Perhaps that will change in the future. But for now, after women leave the bench, it's not the case that it's more likely that a woman will replace that. It's just as likely that a man will replace her. The second idea is that the gender diversity is somehow related to the timing and the renovation of court, right? So if we consider that the claim or the movement towards gender diversity in courts is relatively recent, the timing at which the court renovates its members is likely to matter. If the renovation occurs in kind of like in a long-term way, that claim and that movement towards gender diversity is likely to occur later, because it's harder to renovate the members of the bench, right? So because it doesn't necessarily work like Parliament, where at every X years you change the half of Parliament or the entire Parliament. So the ways in which we renovate courts are different, and that may impact gender diversity. So we're still looking at different ways timing can affect this, but one of the things that we wanted to do is that there's this very interesting research by Escobar-Lemon, where she basically identifies the first woman on each high court, all countries in the world basically. And so we wanted to kind of test if these way pavers, like she described, right? If the first woman, if countries begin this process of gender diversity at an earlier stage, that will impact their long-term diversity, right? So the movement for gender diversity, the earlier it begins, the better the results you have in the long term. But we find this also not to be the case. So unlike Escobar-Lemon's conclusion that breaking the glass ceiling, right, or having these different way pavers open the gates for other women, that's not necessarily an important factor when it comes to gender diversity. I think although the data she collects is very important, the impact that has on long-term diversity is inconclusive according to our data. So apart from gender, I'm also going to talk a little bit about age diversity, which is one of the aspects of courts that almost no one looks at, and yet is kind of like self-evidently important, right? So the age of justices is very likely to impact the way they make decisions and the way people perceive the court and the way people kind of think about the court's decisions and the court as an institution. So we observe that in several different legal systems, there are often minimum age requirements, even in the Constitution, that limit the participation or inclusion of younger justices, right? So if we look at the distribution of age in courts, we see that there really is a sweet spot of about 55, 56 years old, but really in the 50s and 60s that justices are appointed. Kari, can you jump on? Yeah. So you can see that there's kind of almost a normal distribution here, and it's in the 50s and 60s really that justices are appointed, even almost irregardless of the rules of minimum age, as we will see. So we found this with this data point to be the most stable across the entire database. So if we separate by gender, if we separate by region, if we separate by all different types of dimensions, we'll find that the age of appointment of justices is more or less stable throughout. So there seems to be a kind of a connection. That seems to be the sweet spot, regardless of the mechanisms that lead to an appointment of a justice. So in the next slide, I talked a little bit about in the beginning the appointment rules, right? Oftentimes it's 40 years, 45 years, 35 years, or in Brazil it's a range. So the question is, do these appointment rules even matter at all? And our first conclusion is that although they may have other like symbolic importance, when it comes to actually affecting whether young justices are appointed to the courts, we see no real effect at all. If that rule is there or not, countries will tend to appoint older justices as just a matter of. It seems our strongest hypothesis now is that it's probably a cultural idea of what we understand judges to be. We understand judges to be slightly more mature people with more experience. And so we kind of reject the idea of younger justices, irregardless of rules that may exclude them from the process. So those are some of the conclusions that we wanted to share with you guys. We do have some more. So if the Q&A, if any of you are interested, we can kind of talk about that. But that's all. Thank you a lot for your attention.
So, thank you very much, Nicola and Karina. We will follow to the next presentation by Gaurav. Can you please unmute yourself and begin?
Yes.
Okay.
Hi everyone. Thanks to the organizers for inviting me. This is such a great opportunity to share my work, and I will have a set of prepared remarks, which I will begin to deliver now. Okay, it's with quite a heavy heart and an even deeper sense of historical irony that I deliver these comments on my project on the legitimacy of transformative constitutional adjudication in South Africa, India, and Colombia. They arrive at a time when South Africa is reeling under the most serious civil unrest it has witnessed for at least 2 decades. Its flames fanned by a reckless populist who has, in its time in office, sought to bend the rule of law to his own political end. And it would be quite irresponsible of me to not speak about this just a little bit, because our scholarship doesn't happen in a vacuum. But what is most striking, probably, is our collective realization that the project of constitutionalism and the social exclusion which it tries to address in countries in the so-called global south is one that is fragile and requires constant renegotiation and must take everyone along if it is to have any degree of legitimacy and effectiveness. The genesis of my research lies in trying to better understand why the project of transformative constitutionalism has had such diverging paths in India, South Africa, and Colombia. In South Africa, there appears to be a disdain in some quarters of society about the ways in which the Constitution has tinkered around the edges without fully addressing the questions of exclusion and violence faced by the country's Black majority. Some go so far as to say that it is the Constitution that constrains the emancipation of the country's dispossessed. In India, a heavily compromised Supreme Court has appeared to acquiesce to the executive excesses when it comes to inequities in social provisioning, seen most recently in its tardiness in intervening in cases concerning basic supplies to migrant workers in the wake of sudden lockdowns, as well as a number of cases involving vaccine and oxygen supply during the second wave of the pandemic. In a slightly different vein, the Colombian Constitutional Court has been criticized for becoming an avenue for well-financed, well-organized groups to obtain quick relief, often bypassing or skipping queues, while not being able to productively engage with the broader political economy, which produces these differential levels of material deprivation, nor has it been able to affect any kind of broader structural change. Could this have something to do with the focus of the legal industrial complex, comprising the bar, the judiciary, and legal scholars, on primarily juridical avenues towards social transformation? In what ways has the excessive court centrism of the transformative constitutional project, in what ways is it a pathology of the ways in which courts act, of the ways in which it is essentially an elite, sometimes anti-democratic pathway of remedying social injustices? I have, through my work, tried to place the scholarship on the role of courts against the legislature in a democratic society in conversation with the scholarship on transformative constitutionalism. In doing so, I suggest that there are issues of judicial practice and institutional design that contribute to the delegitimation of the phenomenon of transformative constitutional adjudication. Having said that, I acknowledge that transformative constitutionalism is not just about courts, but should be thought of as an approach to legal interpretation as well as institutional design that places at the center the effective transformation of deeply entrenched structures towards a more egalitarian or democratic society. It should also be thought of, as Heinz Klug suggests, as a conceptual arena in which to develop a socio-legal understanding of how a specific constitutional order emerges. Now, why is legitimacy my choice of framing? It is because of the fact that I believe that it is this feature of the enterprise that is most at risk when judicial practice and institutional design act in the kinds of ways that it begins to do. Constitutions themselves are considered to be minimally legitimate. That is, that they enjoy a degree of legitimacy by their mere existence and are usually incapable of achieving ideal legitimacy. Thereafter, the judiciary's involvement, mediation, containment, and expansion of the project of legally bounded transformation is contingent upon the ways in which it acts and whether it is in accordance with the tenets and expectations of a professional and epistemic community of the legal industrial complex, which I spoke of earlier. The relationship is also reflexive on account of the ways that the institutional behavior of the judiciary alters the legitimacy of its involvement and perceptions thereof amongst a range of socially and politically situated actors within the constitutional system. Third, the legitimacy of adjudication may also be epiphenomenal to the broader constitutional project of transformation, but is constitutive of it in important ways. Therefore, the relationship between the legitimacy of the transformative constitutional project and transformative constitutional adjudication should be thought of as being contingent, reflexive, and constitutive. Having developed the relationship between legitimacy and transformative constitutional adjudication, we can now unpack its dimensions. I think of it along 3 or 4 kinds. The first is a largely static moral dimension, which I don't really want to get into too much over here. The second is an interpretive or a doctrinal one. Courts increase their legitimacy along this dimension by the use of rigorous legal reasoning, engaging with textual restrictions that may exist within constitutional texts, such as internally qualified rights, as well as by establishing predictable standards for executive deference. Their legitimacy is compromised by not establishing what Tunis Roux and Ross Dixon have termed doctrinal markers. Doctrinal markers are, first, bases for intervention for courts, which continue to lay the groundwork for later interventions. They often expand the range of acceptable arguments within the legal and professional community. And it can also act as a deferral device for preserving institutional capital in case the court doesn't intervene in a particular case, but lays out a possible path for future litigants. And it can also signal to lower courts the directions which higher courts might take in the future. Take, for example, the case of Colombia, where its constitutional court has wavered on the exact circumstances when individual remedies and structural ones can be obtained, resulting in the impression that the court is sensitive to a range of extra-legal, often political factors while deciding cases. Now, this is a problem because it affects legal certainty, the rule of law, as well as being kind of in conflict with our ideas of the realms of law and politics being hermetically sealed off from each other. Now, whether or not you believe that is true, we can have a conversation about that later. Second, in a related vein, the legitimacy of transformative constitutional adjudication is enhanced when courts are able to clarify the relationship between different systems of law. These often conflict, and what I mean by this are legal systems where there are layers involved, such as those of statutory, common law, and constitutional law. Not doing so often results in a lack of coherence and can, in certain cases, give rise to very absurd results, with a resultant confusion about what rules operate at what time. Take, for example, the case of evictions following land invasions in South Africa. Under the common law, an individual may exert a certain level of force to evict persons from their land without a specific court order, but this is something that is very specifically barred by legislation. Yet, courts have taken varying approaches to this question, pending a clarification of the applicable rules. We've seen a problem with this emerge specifically in the context of the lockdowns, which have been present. Currently, there are level 4 lockdowns in Johannesburg, in Cape Town, and authorities are evicting people despite the fact that level 4 regulations prevent authorities from carrying out such evictions. The second dimension of legitimacy is institutional and is contingent on a range of things, but just illustratively on who is able to access courts and the ways in which courts deal with the broad question of institutional fit, which can be further disaggregated into concerns about democratic legitimacy, information expertise, and the separation of powers. Courts usually engage with this through an expansion of standing rules and the use of experimental models of judicial review that are able to consider a broader range of stakeholder views on remedy formulation and judgment oversight. Legitimacy around this dimension is compromised when courts engage in what I call judicial evasion, which is deciding not to decide. This is most visible in cases from the Supreme Court of India, which through a combination of opaque docket rules and the concentration of far too much power in the hands of the Chief Justice, has opted not to intervene in a range of cases relating to the pandemic on issues of basic goods provision, vaccine, oxygen, and medical supply. A related concern is what I call outcome asymmetry, and the diagonal separation of judicial competence in tiered judicial systems, where there is a wide divergence to questions of rights interpretation and intervention between apex and lower courts, visible in the kinds of differential outcomes that petitioners have been able to obtain from the Constitutional Court of South Africa and the much more conservative Supreme Court of Appeal. In India, we have also seen the arrogation of matters that are pending in lower courts, which tend to have a better record of rights protecting judgments to itself, resulting in not only in delays, but also worse outcomes for petitioners. Now, the third dimension of legitimacy is a sociological one, which I admit I'm not able to explore fully due to the fact that this is not an empirical project. So there's always going to be an epistemic incompleteness to my remarks in this part. And this is influenced by issues such as claim sequencing. So that means is that in case courts seem like a place where people are able to jump the queue and obtain certain kinds of relief, thereby superseding others in this queue, it becomes a bit of a problem. And as a result, these kinds of pathologies affect the ways in which the broader public view the courts in these jurisdictions under study. Now, it is not an overstatement to say that the faith in the constitutional project among the broader public is a delicate matter, something that events in South Africa are currently testament to, and courts must take seriously the risk to broader processes of transformation, which might result from a perception of illegitimacy of their decisions and lower levels of public acceptance of these decisions. Now to what Jonathan termed as the so what question, right? Apart from the ones that I've already discussed, what kind of threats do these present? I'll give you a non-exhaustive list. The first is the risk of political delegitimation, where political actors find it easier to pick apart judicial orders, which are already viewed in some quarters as an elitist exercise, in case they're not well reasoned out. And if they seem to be at odds with the kinds of budgetary priorities that are set by democratically elected and accountable branches, which also might have a result in escalating inter-branch tensions. Finally, social movements, which also play a central role in the exercise of legally bounded social transformation, will benefit from higher levels of predictability and outcome stability, and will be able to strategize their kinds of litigation better. A key takeaway which I want to give you is the political proposition that contestations over social transformation cannot and should not be the province of the judiciary alone. This is, of course, by no means an original claim. However, I wish to suggest that by engaging seriously with the problems that I identify, courts can contribute to enhancing their own legitimacy while being intimately involved in what Robert Kober would consider a juris-generative conversation with the other coordinate branches in a process of legally bound social transformation. So that concludes my remarks, but I just want to say that I think one of the things I'm looking for feedback on with respect to this is and of course this will be harder for those who've not had a chance to read the paper, but essentially the question of breadth versus depth when it comes to a comparative work like this. So that's something that it would be great if I could get some feedback on. But thank you for your attention, and I hope I have kept to time.
Thank you very much, Gaurav, for this interesting presentation. And now we will follow to the next presentation and the last presentation by Lucrecia today. Lucrecia?
Yes, let me try. Can you guys see my my presentation right now? Okay, yes. Good. Sorry.
Thank you.
Just, apologize about that. I'm not very familiar with Microsoft Teams, so that should look better. Okay, thank you, Icon. Thank you, everybody, for being here. The title of my presentation is Difference, Access to Contestation and the Legitimacy of the International Criminal Court, Moving Beyond the ICC Africa Problem. And I should preface by saying this builds on previous work that I have done treating the legitimacy crisis of the ICC, particularly among some African nations, as an issue of a normative crisis, an issue of lack of access to contestation, the inability of stakeholders to really participate in the giving meaning to the Rome Statute and just bringing it to life. A process which I argue and continue to argue has been to some extent monopolized by the court and by a select group of civil society allies. So what's the argument of my paper? Fundamentally, I argue that in a world of enduring differences, cultural differences, regional, national differences, norm contestation is inevitable, it's unavoidable. And that, of course, is going to create challenges for international organizations, or in this case, an international court like the ICC, and global governance. Yet access to contestation for stakeholders, the possibility of a real dialogue and ownership over over the norms that are embodied in these organizations can turn contestation into compromise or even consensus instead of conflict, fostering global governance instead of undermining it. Critical to the legitimacy of the ICC is to further governance at the meso level of global governance through increased access to contestation, as I mentioned before, for all stakeholders. And that means not just states that are party to the treaty, but subnational actors that are touched by the work of the court. Specifically, I argue in this paper, stakeholders' views on complementarity and on the anti-impunity norm should further inform the work and the day-to-day of the court. I further argue that increased access to contestation over the anti-impunity norm, what it means or should mean, would require the repoliticization and contestation of the currently, I would argue, too expansive and too technical understanding of the complementarity principle, because this would help facilitate a compromise between the currently prevailing top-down views on justice and more specifically on what it means to not let crimes go unpunished, and those emerging from local actors. So the background, the theoretical background framework for my argument is fundamentally Wiener's theory of contestation. I don't know if people in the audience are familiar with this theory, but a basic tenet of this theory is that norms are inherently contested and they only acquire meaning in context, meaning in use. Therefore, or in other words, you do not have a definite meaning of the norm before you implement it, before you put it into practice. And you are to expect that you are going to have some manner of debate or some degree of debate around what the meaning of those norms are when you implement them. But I'm getting ahead of myself because I should clarify that Wiener also speaks of 3 different types of norms and 3 dimensions of validity of norms. She argues that validity entails formal, social, and cultural validation, and that we speak of, or we should understand there are 3 fundamental types of norms. Fundamental norms, the abstract general norms that tend to be vague, like justice or sovereignty. Standardized procedure, the very specific guidelines, like the articles that we'll find in a treaty, and between them, organizing principles, which are more political compromises in a way, which can fill the gap between fundamental norms and standardized procedures, where a lot of the conflict at the moment of implementation of rules tends to take place. How do we implement these articles in light of our basic understandings of those fundamental norms? But Wiener further argues that access to contestation, what she calls contestedness, is critical to the legitimacy of validity of norms, and that increased access to contestation, both reactive and proactive, that means the ability of stakeholders to reject norms, reactive contestation, or to engage creatively with the construction of the meaning of norms, proactive contestation, and access to both of these can further the legitimacy of norms, and therefore it can also further the legitimacy of institutions that embody them. In addition to taking Wiener's theory as a framework of analysis, I also draw from debates on norm collisions, of which I think the ICC Africa problem represents an example, and in particularly the work of Krede, Sonnen, and Zürn, who argue that the impact of norm collisions, of what they call interface conflicts on global governance, will depend on how they are managed. And in particular, they argue that cooperative management will promote global governance order, not undermine it, even though we see a norm collision, and that norm-based cooperative management is the most order-generating type of conflict management. In terms of methodology and methods, I am trying to draw from Pouliot and his idea of subjectivism, which starts research at the level of individuals and their own perspectives on the subject, in this case, the meaning of anti-impunity and the meaning of other relevant norms, then builds it into a more objective account, which places those individual perspectives in context, try to understand the meaning in context, and then just places those meanings in a more in a broader framework that historicizes them, that just puts them in context, understanding how they play out in terms of pre-existing relations of power and whatnot. The methods I used to try to achieve this include the analysis of documents like NGO reports, parliamentary debates, news articles. Ideally, I would include some interviews with involved individuals, and then just process tracing and historicizing narratives in order to just provide that context and historical background that I mentioned before. The two norms that are central to my analysis, as I already mentioned, are the principle of complementarity and the anti-impunity norm. And the anti-impunity norm dictates that the just society has an obligation to ensure that the worst crimes don't go unpunished. More specifically, in relation to the ICC, it means that the international society has an obligation to ensure that the worst international crimes, genocide, war crimes, crimes against humanity, aggression, don't go unpunished. And by unpunished, the prevailing understanding at the court is that means that there will be a criminal trial, a potential incarceration for those found guilty. The complementarity principle, in turn, establishes that the ICC may only exercise jurisdiction over cases that states are unwilling or unable to investigate and prosecute themselves. Following Wiener's classification of fundamental norms, organizing principles, standardized procedures, I would argue that both complementarity and anti-impunity norm are organizing principles. And I should apologize here to Jacob, because in the paper, I was treating anti-impunity as a fundamental norm, which is the way I had treated it in previous work, but it came clear to me that when we move below the state level and we get inside the state, there is a level of disagreement around the meaning of anti-impunity that doesn't really fit well with fundamental norms. So these are organizing principles, or are those norms that can fill in the gap between fundamental norms and standardized procedures. It's worth noticing that I'm talking about complementarity here as an organizing principle, as a basic understanding of the relationship between states and the ICC, which makes the ICC a court of last resort. When it comes to the specific wording in the Rome Statute, presenting complementarity as admissibility criterion, that would be closer to what Wiener calls a standardized procedure. And in line with her theory, I fully expect that the key elements of these two definitions are going to be contested, particularly at the implementation stage, because of cultural differences across the stakeholders. So the boundaries of society and crimes and punishment in relation to the anti-impunity norm, and the meaning of unwilling and unable, and more generally, the obligations derived from the Rome Statute associated with the complementarity principle are all going to be a matter of debate and are going to be likely the focus of stakeholders' contestation across different locales. So empirically for the paper, I focus on Uganda and Colombia, and I'm trying to understand what meanings anti-impunity and the relationship between the court and states emerges from the ground. And what do I mean by from the ground? Well, I'm looking at statements by local civil society organizations and political elites. When I say local civil society organizations, I'm thinking national, subnational, or regional organizations. I'm trying to focus on this as opposed to local chapters of international organizations like Amnesty International or Human Rights Watch, or organizations such as those who I think represent a cosmopolitan view that I expect will be different from that emerging from the ground. And these are two interesting cases because they are both countries where there were expectations of justice in the context of ongoing conflicts, and both cases received the attention of the ICC. In Uganda, in the case of Uganda, we have obviously the first case for the ICC, a self-referral, and all the controversy around that. That just the state used this instrumentally to focus on what their enemies were doing, and just prevent the ICC from focusing on what the government had done. But in my work, I'm more specifically focused on debates and the meanings of anti-impunity and complementarity that emerge around the discussions of the implementation law and the Amnesties Act. And in Colombia, we have a situation in which the country has been under preliminary examination by the Office of the Prosecutors since 2004. Close attention has always been paid. A lot of back and forth communications between different actors in the country and the Office of the Prosecutor. And in particular, I focus on discussions and arguments that emerged around the 2016 final accord. So In this table, I summarize, and I cannot emphasize enough how preliminary this is and how early I am in the process, some of the understandings of anti-impunity and complementarity that have emerged among political elites and civil society in the case of Uganda. So what I find in terms of the meaning of anti-impunity among local elites had to do with a lot of emphasis on traditional justice mechanisms when it comes to what it means to punish, or give consequences to those who have committed crimes. A lot of emphasis on reparation and reconciliation over retribution. The idea that punishment doesn't have to entail trial or incarceration, that material restitution is an alternative, a strong focus on victims, and a strong support for amnesties. That the use of amnesties does not necessarily deny the idea of someone perpetrated a crime, it has consequences. The level of political elites, I did not, or I have not so far perceived such a strong support for traditional justice mechanisms, but there is a strong support for the use of amnesties, and this has to do with also the relationship between fundamental norms like justice, sovereignty, and peace that you can see present in the discourses of political elites. In terms of the relationship between the ICC and states, among local civil society organizations, I can see some level of resentment, in some cases very high, against ICC involvement because they perceive it as being bad for peace, and because they also interestingly perceive it as not providing justice, at least not justice in the sense that they understand justice. And also, obviously, there is, as I mentioned before, a perception of bias because of the way that that self-referral played out. And it's also a demand in terms of that relationship between ICC and states that the court makes more room for traditional justice mechanisms, that accepts that these mechanisms are indeed justice and are indeed compatible with, as we said before, the anti-impunity norm. At the level of local elites, we see a very instrumental relation with the ICC and a perception that the ICC and its allies, because again, there have been particular specific references to civil society pushing against the use of amnesties and other measures, a strong emphasis on them not interfering in the peace process and not interfering on the domestic affairs of Uganda, provided that Uganda is trying to take some action, that there should be no interference. And also there were statements that were very, I think, interesting, so far as the perception is not that this is an ICC problem, but an international law problem more broadly, which is discussed as not really taking under consideration the interests and the values and the priorities of the Ugandan people, and it's up to Uganda to protect them and Uganda's representatives. Now, in the case of Colombia, I have a different situation here. At least what I have seen so far is that a lot of think tanks, NGOs, and academics actually defended the prevailing meaning of the anti-impunity norm, speaking against amnesties. And similarly, they defended the role of the ICC in a very traditional understanding of complementarity, which for them meant that if the state didn't really deal with the crimes and issue amnesties, or just focus on some of the perpetrators and not all, then the ICC should step in. One thing that I'm very interested in doing is adding a geographical dimension to this analysis, because when the plebiscite for the peace accord, took place, and there was a very clear geographical distinction between supporters and detractors. And those living in areas closer to the conflict were much more in favor of the accord than those living away from the conflict. And the urban-rural divide in that regard also play a role because of the same reason. So I'm expecting that many of these NGOs and academics and think tanks operate in cities, and therefore they just replicated that geographical dimension that I mentioned before. So I'm interested in looking into that further. Now, in terms of political elites, I also saw a lot of support for a very restricted understanding of anti-impunity, mobilized against the use of amnesties. But at the same time, I saw a lot of pushback on the part of the executive, and a pushback that was very interestingly articulated, not in cold political terms, but by using legal arguments. and even the record of the ICC of focusing just on those most responsible in order to justify, a very particular and narrow and peace-oriented approach. And in terms of the relationship with the ICC, yes, there is an understanding that the ICC should play a role and that role could be instrumental for advancing peace and justice for Colombia. But, I think there is a big division once again between those who supported the accord and those who didn't in terms of understanding the role of the ICC in the process. And this in this table, I just summarize a little bit, the revision of the anti-impunity norm that emerges from this analysis. And, every norm has an actor that becomes responsible for a conduct and a prohibited or like a direct, a conduct where the norm focuses and some consequences. So I organize it around that. And I see that the biggest issue, the highest level of contestation is really around the consequences. At least that's what comes from the evidence so far. The idea of criminal punishment being the only alternative is the notion that is most highly contested. And, that calls for, maybe rethinking about what it means to not allowing, crimes to go unpunished by de-emphasizing, potentially redefining punishment more along the lines of restorative as opposed to retributive deterrent functions. The final argument I wanted to make, going back to my original argument, is that I see as critical to repoliticizing and renegotiating the meaning of anti-impunity to repoliticize and renegotiate the meaning of complementarity. I see that as a necessary precondition for rethinking about what anti-impunity means. In principle, the complementarity principle really is equipped to accommodate different acceptions of justice. It just hasn't been used in these ways. It's treated increasingly as a technical issue, and the turn towards positive complementarity really reduce, in my opinion, the role of the states and put the states in a secondary seat, because even if states should have the first take, the idea is that states should mirror, the understanding overall these issues, including, the general understanding of justice, should mirror those understandings as they are in the Rome Statute. So in order to rethink the anti-impunity norm, we need to rethink complementarity, and I mean going beyond just empowering states, but I mean just really allowing states to define their own relationship with the court and their own meaning of justice. I'm running a little bit here because I'm pretty sure I'm running out of time. Wiener emphasizes how access to contestation is critical to building that, or to fill in that gap between fundamental norms and standardized procedures. And I do make that argument as well, that increased contestedness in general is necessary for the process. So all in all, predictable conflict in the implementation of the Rome Statute has been inflamed by limited access to contestation, and renegotiating critical organizing principles is very necessary to move the ICC forward. And to reveal the legitimacy of the court. Complementarity as it exists today, expansive, technical, needs to be repoliticized as a precondition for anti-impunity to be successfully renegotiated. And revised complementarity, and the key here is that a revised understanding of complementarity would allow for varied meanings of what it means not to let crimes go unpunished, what it means to prevent impunity to coexist in the ICC community. And in the slides you can see, examples that I highlighted, of the perceptions among Ugandans and Colombians in this case. And I connecting to the other part of the theoretical argument, I wanted to, finish by saying norm-based cooperative management, took place in Colombia much more than it did in Uganda, and I think the Colombia model presents a good, guideline on how to foster justice around the ICC. This is important. This goes beyond radical complementarity or tempered complementarity, but it's a fundamental renegotiation of the relationship between fundamental norms and standardized procedures. So it goes really deeper than a lot of what we have seen in the literature. And in terms of contributing to our understanding of norm-based cooperative management, management. I wanted to highlight the importance of resources, and I don't mean money or any other kind of material resources, but really more intellectual resources. Colombia's representatives were able to articulate using international law really good responses to strong advances on the part of the ICC, and I think this was critical to their success. I'm sorry I went over time, and thank you so much for your time.
Thank you very much, Lucrecia. It was really interesting and a great presentation. And now I will leave the floor to Jacob for commenting on all these 3 papers.
Thank you. I recognize we're running a little over time, so I would just say if people do have questions, they should feel free to raise their hands or type them into the box now, and I'll try to incorporate that into how extensively I give comments. One consolation for the authors, I have written comments as well, which you'll receive short in the next couple of days. All right, so let me just start with a few general comments. First of all, these 3 papers were all fantastic and in very sort of distinctive ways. I think each of them showed certain characteristics of works in progress, and that's a good thing, right? Each of them was still a project that's still being formed. What was apparent in each of them was the sort of passion and curiosity of the authors as they're working through these ideas. The sort of obverse of that needs to be channeled and disciplined is that where each of the papers is going is still being developed, and I think each of them to be turned into a successful piece of scholarship that is an academic product needs to be focused and disciplined and developed in certain ways. I think it's a good thing to say that I think for each of these, and I mean this sincerely for each of the 3, there are probably multiple papers that could be pulled out. And figuring out how to do that, the right way to do that, how to turn it into a sort of single product that can be presented to a journal, whether it's Global Constitutionalism or another journal, is one of the major facets. And in the sort of spirit of Jonathan's comments, for each of the papers, I'll trying to be offering comments on how to do that. So with that in mind, let me turn to each of the 3 papers. So the presentations by Nicola and Karina, I thought this was a paper really important and also very topical. And it's topical in sort of 2 respects. The idea of the importance of a diverse judiciary is one that's been rising in importance now for a couple of decades. I know it's received particular attention in UK public law. So I think this is an important topic. I also think the deployment of empirical methods to analyze it is of importance. And one thing I would encourage you to do is to think of ways that you could not merely address the data, but think of what are innovative methods that you could deploy to address them. A book in the global constitutionalism space that's been receiving a great deal of attention is Chilton and Versteeg, How Constitutional Rights Matter. I would consider giving that a look. I think it has, its virtues and its limits, just like any piece of scholarship. But what it is a brilliant attempt of how you can deploy diverse methods. You guys have a great data set. And what I would encourage you to do is think about not merely ways you can expand the data set or substantive ways you can extend it, but ways you could deploy innovative methodologies. And building on that point, I think the paper as framed is clearly something of a bed or a factory for producing multiple papers. One of the challenges you guys will face is how you want to approach this, how many papers you want to spin out of it. The more methodologically innovative you can be, particularly in terms of addressing the data you already have, the more you'll be able to extract from it. Now, an internal challenge there is doing stuff that's methodologically innovative, but also familiar and apparent to the existing people who work on this. I have sort of, and this will be true for each of the papers I comment on, I have sort of 2 sets of observations. One that are sort of more pitched at the procedural level, how to develop the paper as a matter of fitting it into the discipline principle, and 1 substantive observations. I'm going to start with the sort of procedural observations. So I think the literature review here is sound. I think there is a question of where and how much. And again, this could be a separate paper. It could be that in some papers you fix this, in others that you don't. Do you want to engage in a critical analysis of some of the ideals that underlie the project? I think the concept of diversity in the judiciary faces an intrinsic, I don't want to necessarily call it attention, I would say a puzzle or a sort of threshold question of, do we treat diversity as a political concept? And if so, is it one that should be first order addressed in judicial composition, or first order conceptualized as a matter of judicial composition? Now, I recognize that the composition of the judiciary is necessarily going to have political elements, right? But one question is, should the selection of judges be the level at which that occurs? One could also imagine saying, we're not going to think about selection of diversity within the judiciary as a first order normative question. We're going to look at things like access to education, access to elite legal professions, access to the pipeline that feeds into the judiciary. Why am I saying this? Because if we think about rule of law as the concept of neutrality, one could say that that concept of neutrality might intrinsically require absconding away from particular values of politics. Now, I'm not stating, I'm merely posing that as a puzzle or a question that you could ask. The question becomes, is diversity the type of political value that is in tension or perhaps falls outside the ken of rule of law? I think those questions are elicited by your paper. I don't think you draw them out yet, and I don't think that would necessarily be the main thrust of your project. But as a theorist reading this paper, that was one thing that became apparent to me that would be particularly interesting. And I thought your empirical observation that the judiciary is diversifying more rapidly than legislatures says something really interesting about that. And again, there's even another, this is a separate point. Does that say something about the way norms infiltrate constitutional structures? We have this norm of diversity that for some reason is infiltrating the judiciary, an elite institution typically, more rapidly than it is infiltrating the legislature. There's actually a paradox there, given that we would think diversity is more naturally classified perhaps as a political norm, whereas the judiciary should, the sort of composition of the judiciary could arguably, and again, I'm not settling this, I'm merely posing this as a question, if we think that selection of the judiciary should be more closely confined to rule of law, why is the judiciary conforming to this political norm more rapidly, right? And this is sort of blended procedural substantive observation. It's simply showing this is one paper that you could pull out of this, in addition to papers that might be more thoroughly empiric. And I think there's certainly more than one paper here. I think how many papers there are will depend on how creatively you want to proceed sort of with your methodological analysis. Some sort of lower level observations, and this is sort of drawing off my expertise in the US federal system. The accent is not faked. I wonder if the federal system, and in particular the division into geographic circuits, creates potential natural experiment for you. The different circuits are going to have, to some degree, different demographic characteristics. It would be really interesting to break the US into its constituent circuits, of its constituent appellate courts, and say, how are these elements of diversity differentiating among these different courts? And this goes to the point of methodological, empirical creativity that your project has a lot of room for. I would encourage you to try and pursue those out. That's one of the way, this is, I think, becoming increasingly common in legal and social science literature. People are evaluated not merely on what their conclusions are, but on how creatively they deploy methods. That sort of looking to an intrinsic experimental quality in the data set could be really valuable. In the paper itself, less so in the presentation, you focused primarily on gender. We sort of recognize the diversity of dimensions of diversity in your introduction. This will be a challenge that you face of how do you want to break those apart. There will be an intersectionality element that would emerge. I would encourage you at this point in the project where it seems as though your analyses are sort of working with the data in a fairly direct way. Figure out what the trends within each of those elements are, and then maybe proceed with more nuanced or more intersectional analysis. And a final point, and this is going back to my idea, the observation that there's something interesting about the fact that diversity is infiltrating legislatures more rapidly than, infiltrating judiciaries more rapidly than infiltrating legislatures. I wonder if this says something about the way that substantive norms enter systems does the judiciary reflect elite norms, judiciary selection of the judiciary reflect elite norms in a way that selection of the representatives is not? Could this potentially point to an underlying conflict? Now, this is a different type of suggestion than the methodological one, right? So this suggests there are at least two axes on which you can continue to develop this project. One is increasing methodological innovation, looking at the data set in new and different ways, using new and different modes of quantitative analysis. Another is looking at new norms and new ideals, new sort of substantive hypotheses that you can derive. And I wish I could give you the magic bullet formula. You know, someone says, well, how do you write a good paper? What's the right point to hit? You don't know until you've done it. If there were a magical formula, everyone would be cranking out perfect papers all the time. On the whole, a really promising project. There's an enormous amount of potential here. The question will be, in what directions do you develop it, and how do you take the observations that you make and fit them into the appropriate boxes and find the appropriate platforms for publishing them. Okay. Moving on to Gaurav's paper. So you sort of preempted one of the points I was going to make. You asked about breadth versus depth. This is a paper that really aspires to both. I think the result is that it spreads itself too thinly, and not in that it lacks breadth or depth, but in attempting to cover both of these, it doesn't give any one idea sufficient attention. What does this mean? You need to figure out which specific ideas you want to hold fixed in any particular project. Right now, the paper as a whole feels more like a schematic for a book project than it does like a single article, right? And I think the standard way to do this, and the word discipline here I like because it has sort of two meanings. You need to approach the discipline and say, well, what ideas are fixed in the discipline, and which ones do I want to hold fixed in any particular paper? And then which ones do I want to make mutable by critiquing them or by combining them in a novel way? You need to think about this semiotically. What you are trying to do here, ultimately, this is about language, not really about individual words, but the language of concepts by which we make our ideas perceptible to the audience. And you need to say, which ones am I going to hold constant so that a particular piece of scholarship is readily cognizable to the people I am trying to speak to, right? One result of the fact that you don't do this, that you have so much that you're trying to critique, is that you spend an enormous amount of the paper engaging in table setting, either outlining or saying, here are concepts I'm going to deal with. No individual concept gets sufficient attention. There were particular points where this became apparent to me, right? When I look at pages 10 through 12, and I know this isn't particularly useful to the rest of this, so I won't dwell on this too much in this presentation. 10 to 12, you sort of say, well, constitutional adjudication is contingent, reflexive, and constitutive. You then try to critique each of these ideas. This is already occurring quite far into the paper, and you're already engaging in table setting. No one of these ideas you are able to fully unpack. And I would say, and in an interesting way, you'll notice certain sort of echoes of this in my comments to Lucretia. You need to figure out what ideas you want to hold constant. And it's not as simple kind of mechanical process of saying, oh, I'm going to hold contingent and reflexive constant look constitutive. That's one way of thinking about it, but that's too mechanical if that's what you take away. The point is, what contribution are you trying to make to the scholarship? Maybe it's destabilizing all three of these at a higher level. Maybe it's combining them or reframing them some way, but you need to take the literature as a given and speak to that audience. And I think another way this comes across in your paper is your attempt to both look at particular problems and look at high-level general theoretical abstractions. I think this came across in your presentation as well. You started by talking about these very compelling immediate emergencies in South Africa and India, but then you want to somehow link them to these high-level ideas. It's possible to do that, but the more you try to cross that bridge, the more you have to be very focused in terms of what you're looking at. How are you using a particular real-life example or real-life examples to look at a very particular problem? In the paper as it stands, you have so many moving parts that the reader doesn't quite know where to grasp into. And thinking about readers as participants in a shared project of scholarship, they're not going to go, well, where is this person trying to make a contribution? Now, a few substantive comments. An implicit, I think, commitment of yours is that you are trying to use the courts to solve systemic problems. Now, as I'm sure you're familiar, and as it comes across in your paper, this is a critiqued idea. One, instead of sort of reviewing this well-known idea, I'm just going to say something in particular. Is there something about this state of socio-political development of the polities where you think this judicial role is particularly important, that raises tension or raises an unresolved question? We would be very surprised, I think, in a Nordic or even in a country like the U.S., which is, I would say, less stable than the Nordics right now constitutionally, to see the court performing this transformative role. Does this suggest the idea of transformative constitutionalism needs itself to be contextualized within a broader framework of sociological development? Right, so that what the judiciary is actually doing, and you cite the work of Taran Kaitan, is this suggesting a broader framework in which the idea of guarantor institutions, or in which the courts as this type of ontologically higher order institution plays this particular role, right? Now, notice this would be one very particular thread that you draw out of the paper. I thought that was quite interesting. You elicited this concern. I don't think you were able to either squarely confront it because you were trying to cover so many ideas, but that was one point that I thought came out in a particularly interesting way. Does it suggest that the constitutional scholarship is itself contextualized within a theory of social development or within a comparative developmental context? Okay. Finally, moving on to Lucretia. Again, I thought, this is a paper that I would say most squarely faced an existing problem within global constitutionalism. It's too bad Antje isn't here because this engages so much with her expertise. I think there is a similar need to figure out where you're going to go for this particular paper. And again, it seems like there are at least two papers. There's one about the concepts of norm contestation, complementarity, and it came out more in your presentation in the paper, anti-impunity. And you can see, as you warned me, you changed the conceptual level that you were placing anti-impunity. There's a paper there. There's also a paper about these case studies, about the manifestations, which might lean more towards comparative constitutionalism as opposed to a theoretical engagement with the ideals of global constitutionalism. You're going to need to figure out where you want to take these. I mean, I think what became apparent in your presentation is so much content you're still juggling. Like Gaurav's paper, you're going to need to discipline yourself and say, well, where exactly am I making a contribution to the scholarship? I could tell both by your draft and your presentation, this is sort of the project in the middle phases. You haven't exactly figured that out yet, but it's going to be clarity in presenting to the audience that's going to be critical here. My own substantive views, given I don't work in this core area, and this is moving from the sort of strategic comments to the substantive comments, there's this, clearly you have this hierarchy that I think that you're still working out between the relationship between norm contestation as a principle that can guide us in thinking about global constitutionalism and the ideas of complementarity and anti-impunity. At one level, you want to see complementarity and norm contestation as potentially in conflict, but in another way, you want to see, I think, norm contest, complementarity, and I think also anti-impunity as encapsulated within the idea of norm contestation. There are different ways you could take this. One is to observe tension within our conceptualization of these ideas. Another is to say the scholarship is using the idea of norm contestation in a potentially unstable or ambiguous way, where it's both being used to encapsulate these hierarchically lower tier, I don't mean in a pejorative way, just sort of following within the idea of norm contestation, but then they're also being put in tension with norm contestation. My own impulse reflects sort of my philosophical training, so may not be as useful to you to say, well, these ideas, in my view, are not the bedrock normative ones that guide global constitutionalism. There must be some normatively deeper principle that is being elicited here, whether it's self-determination of a sovereign polity emerging from popular will, whether it's objective universal values that we can falsify through some sort of deliberative process. All three of the ideas that are central to your paper are reflecting that. Whether you want to engage with that, I mean, I'm a little tentative saying that's because you already have so much going on, but that's what immediately emerges to me. The reason I think it might be useful for you is it might help you sort out how you're conceptualizing of the relationship between norm contestation, complementarity, and anti-impunity as principles. All right, I want to make sure we have enough time for other comments or questions. 3 fantastic papers. I learned a lot from reading each of them, and I think there's enormous promise in each of the projects, and I look forward to seeing these projects develop. I'm really excited for that. And with that, I will mute myself and hand it back over to Aigen. Thank you so much.
Thank you very much, Jacob, for this feedback. I think it was really great and detailed, and surely it will be very useful for you all. So I know that we have really little time left, but it would be great if the 3 presenters, let's say 3 diverse presentations, the authors would react very quickly to Jacob's comments. So, but please keep this short, because we can then look at the other comments. So we can start with Nicola and Karina. Could you please react to Jacob's feedback if you want, obviously?
Yes, well, Jacob, thank you so much for your feedback. It's really valuable to us. I mean, we really concentrated all of our efforts in this first stage on actually building the database and getting all the data, which was a complicated process in and of itself. But I think you identified our main challenges, which really are seeing how we present this data and how we analyze it in a creative and different way. As of now, I think the data is a little bit static still. It's too much. This is what happens, and it's not enough about how that interlocks and interconnects with different ideas. So, but we really appreciate the feedback, and we'll definitely take it into consideration. Thanks.
Yeah, thanks, Jacob. Yeah, I think I agree with you. So, I mean, even in some other places that I had presented this, I was encouraged to spin it off into at least 2 papers. So I think what I would like to do is to do something with pathologies of constitutional adjudication when it deals with questions of this nature. And I do agree that there are a bunch of balls which I throw in the air, which I don't always end up catching. So thanks a lot. So, you know, I mean, and I'll await your written comments. So thanks a lot.
One thing I would say very quickly, I don't think the paper should just be, you know, some papers you look at them, you think you can split this in 2. With yours, I think it will be more pulling out the 2 ideas. There will need to be a bit of work of actually pulling apart the threads and figuring out what those 2 papers are instead of just cracking it in half, like it can be done with some papers.
Yeah, thanks.
I'm just going to echo everyone else, and thanks, Jacob, for the comments. I struggle very much with thinking about this paper as purely theoretical, you know, so the idea of like the cases on one side, the discussion of anti-impunity and complementarity on the other one's like, how can I do one without the other, without that empirical foundation? But I will really think about it very much. And I would love to hear more about that tension that you perceive between contestation and complementarity and impunity, because I'm not very sure, you know, how that played out in the paper. So I really look forward to the written comments. Thank you so much, Jacob.
Thank you very much for you all. So do we have any questions, any comments? I don't see anybody's.
If there are no, I'd like.
Yeah, but yeah.
Jessica just raised her hand. Yep. Okay.
Jessica, please, can you turn on your video if you want? Just unmute yourself.
Yeah, perfect. I did. Very, very brief. There's little time left, as you noted earlier. I do have a question for the first presentation on legality, judiciary, and justice. I guess it's a very, very current, relevant issue if you consider developments in the US under Trump. I suppose the Supreme Court, sort of the political shaping. It's a reoccurring issue in Europe as well. If you consider Poland, for example, Supreme Court, and I'm not sure if you heard about the infringement proceedings by the European Commission. So that's a very international, multilateral sort of issue as well. Very exciting to follow these sort of developments in terms of sort of the internal functioning. I would say. I mean, sort of diversity issues. I'm wondering to what extent, I mean, you sort of touched upon it, but I'm wondering to what extent intersectional discrimination would play a role. You touched upon gender, you touched upon age. I think that's a very relevant topic as well, and based on your data, there's a lot of potential to develop on that. Not talking as a sociologist, let's say, as if we would address this as a law person, sort of different grounds of discrimination. If you think that's relevant at all, I mean, that's another question as well. Well, very exciting research. Thank you so much. That was it on my part.
Do you want to react to this comment, Nicola and Karina?
Kari, you want to go or you want me to go?
Yes, I can go. It's a very interesting question. We were very excited about the intersectional perspectives on our database, since we collected many data based on origin and also educational background. So we are still trying to manage all this data to employ different methods and try to deep investigations in some regions and some countries' perspectives. For example, it's hard to, for example, in America, we found that there is a very interesting connection about, for example, the participation in courts of Black women, for example. There's a whole new perspective on that. And so we're trying to establish some connections, but mainly we are doing that among regions, so it's easier to make this connection. So the intersectional perspective, we're dealing with it. It's a very interesting perspective. So thank you for your observation, and we certainly would take it as a very good suggestion for our research.
Thank you. Any other comments or questions?
Again, I'm seeing one from
yes,
Ahmed, I think.
Ahmed, yeah. Yes, please, Ahmed.
Hello. Can you hear me? Thank you very much. My question goes to Professor Jacob Esler. During your intervention about the ICC paper, you mentioned the contestation, non-contestation as a factor on creation of ambiguity. And normally I read ambiguity on interpretation of the legal text or the legal procedure, but as your intervention, do you think norm contestation itself is a substantially factor creating ambiguity within the legal process or procedure or the text?
I wonder.
Sorry, I think it was for Lucretia, right?
Was this for you, Lucretia? Yeah, yeah.
I'm not sure I understand, but I wonder if we are talking about the same exact thing when we talk about contestation. From my take as a art theorist, looking at norms more generally, and sometimes the legal manifestation of those norms versus what you were talking about in terms of interpreting legal texts. A starting point for my analysis is that norms are inherently contested and they do not have meaning before they are implemented. I know that some legal theorists have a similar take in which, the interpretation of the rule really makes a rule, like critical legal studies, that kind of tradition. But I don't know that that's the prevailing view. And I'm not sure if I'm using contestation, to rephrase, I'm not sure if I'm using contestation in my analysis in the same way that you are using contestation in your inquiry. Can you tell me a little bit about how you are, thinking about contestation to see if we can, if we are talking about the same thing and, I could better address your question?
Okay, thank you very much. In the ICC case, the understanding of complementary is and conceiving complementary is an act of interpretation of the text of Rome Statute in one view, for example. But at your stand of point, you talk about the reorganization or restructure of such norm. So that reconsideration and restructuring of that norm as the collective parties of the that legal text create ambiguity within the process.
Okay, so as I mentioned in the presentation, I can see complementarity in two ways. As a standardized procedure, like the articles, the text in the Rome Statute that is an admissibility criterion, and then more broadly, as the principle that defines the relationship between the court and states and makes the court a court of last resort. What does that mean? I mean, the initial intention of the negotiations was not positive complementarity. It wasn't the idea that now every domestic system needs to incorporate all the crimes in the Rome Statute in the way they are defined and just replicate that. So in the same way that it went in that direction, I think it can go in a different direction, and that is not undermining the law, that's just reinterpreting it in a way that I think will be conducive to furthering the legitimacy of the court. I hope that does answer the question. If not, I'm sorry, I can try to find a different angle.
All right, thank you very much for this question, Ahmed. I don't see any other questions, but if we have a couple of minutes, you can add your comments or questions, otherwise we can wrap up. Jacob, should we wrap up? Yeah. So thank you very much for all your presentations. I think it was a really great day. Both of the panels was really very great and wonderful presentations today. Thank you for all your contributions and being here. And I would like to let you know that tomorrow we have the second day of the workshop. So we will be here at 9:45 a.m. in the morning and 2 p.m. for the afternoon session. We look forward to seeing many of you there. So I think now we can, yeah.
And just very quickly, thank you, Aigen, for running the event, and thanks to everyone for attending. Really appreciate it. Fantastic set of papers in both panels.
Yeah, see you soon. Take care.
Thank you everyone.
We can we can upload people here by Jonathan's method. Yeah. See you.
Ciao.
See everyone tomorrow.